Please proceed.
I want to start by associating myself with the remarks of my very well-spoken colleague, Senator Kissel. Obviously, this is a very difficult issue to speak about, and even more difficult to speak out in opposition to. However, I feel compelled to do so. I think that this is questionable public policy, and despite the circumstances that led to it, I believe it deserves the same scrutiny as anything else we do, and possibly even more so. Being here all the way back after the tragedy in Sandy Hook gives me some perspective and reminds me that it is not a good idea to make public policy based on an emotional response to a tragedy. It is much more important that we get these things right. Like everyone else, I am saddened by the terrible tragedy and the loss of Ethan Song. I cannot imagine the pain that his family is feeling, and I completely understand their desire to achieve some kind of justice and to do something in his memory. But I have concerns about what the actual bill language says. In truth, it makes very minor changes to what is an already existing law. And that should give us some pause, because the existing law was clearly ineffective in preventing what occurs. And I don't know why anyone would think that the minor changes that we're making in the law with this bill would achieve a different result. And outside of being able to say that we did something here, I don't know what the end game is as far as public policy in trying to prevent a further tragedy. Are we trying to change the law in a way to capture the circumstances that occurred in Ethan's case, to make that homeowner a criminal? I think it's important that people understand exactly what happened. I have scoured the news reports. I've read the police report. Some things we don't know, but what we do know is that the firearm was stored in a closet in the master bedroom. The gun was unloaded, it had a trigger lock, and it was in a cardboard box inside a Tupperware container. The ammunition was separate, but also contained in a cardboard box, presumably in the same closet. Apparently, Ethan was friendly with that homeowner's child, and together they went into the parents' master bedroom, into the closet, and discovered this firearm. Some say that might have happened at a previous time, and he was aware of where that was. But either way, that's the situation. And as a result, a horrible, horrible tragedy occurred. I want to just talk about the language in the bill so we understand exactly what it says. It starts by saying that no person shall store a loaded or unloaded firearm in premises that are under their control. This is a pretty broad term, and it raises some concerns for me, because it doesn't just necessarily apply to the person who owns that home, but I can think of a number of other circumstances where someone might be in control of someone's home. Even a babysitter who is taking the place of control of the home from someone's parents when they go out for a Saturday night date or something like that could potentially be caught up in control of someone's home. Even a realtor showing a property. I'm a real estate agent, and generally speaking, I try and keep my clients with me and be respectful of someone's home when I'm showing that property. But that's not always possible, especially when there might be young children around and you're trying to keep them corralled. Further, it goes on to say that the firearm must be kept in a securely locked box or other container. It doesn't say what a securely locked box is. It doesn't say that the box must be made of metal. It does not say that it must be secure enough that someone could not break into it with the skills and household implements that might be available to a teenager. It just says a securely locked box. Does that mean a toolbox? Does it mean a jewelry box? Does it mean, more appropriately, a safe? And why bother even indicating that it has to be a securely locked box if it is still acceptable in this language to store it in an other container? What could an other container be? If you go on to line 12, it talks about in a manner which a reasonable person would believe to be secure. This is another broad term. And I'm going to make a point in a few minutes about why I'm talking about these broad terms. But it's important to note that that's exactly what's happening here. This language can capture things outside the circumstances that I think that we all would agree might be worthy of a criminal act. But in this particular case, we need to ask ourselves, was the homeowner, in the Ethan's case, someone who reasonably believed his firearms were secure? And that's the question before us, really, in a lot of ways in this bill. But I would submit that that depends on who you ask. There was another terrible tragedy that happened in Colorado recently where a young person, 16 years old, and their friend who was 18 broke into their parents' gun cabinet in their home and took the firearms, and later there was a shooting at a school. I don't know. Part of me says, no, it's not reasonable to believe that the person in charge of the premises thought that they were leaving the guns in a negligent way. I think they probably believed they were doing it in a reasonable way. But you have to ask yourself whether it's unreasonable to think that a teenager in a wood and glass gun case is enough to stop them if their desire is to actually get into it. I think that's a subjective term. And the reason why I bring this up is because this bill goes pretty far. In Section 2, what it does is it makes someone strictly liable. And strictly liable means that there is no requirement under the law to prove that the person, in this case, the person who has the premises under their control, is actually responsible, just that the facts occurred. In fact, there's only 5 cases in our Connecticut law where the term strictly liable shows up. I asked the Office of Legislative Research to provide a document that shows those cases, and one of them is the current law. But it's a rare item where we say someone is strictly liable without really a review of the facts. I'll just read from the report. It says, under this doctrine, an injured person is not required to show that his or her loss was caused by the defendant's negligence. It is sufficient to show only that the defendant engaged in ultra-hazardous activity that caused the defendant's loss. And I can understand what ultra-hazardous activity is. I mean, storing toxic waste or something like that. But to secure a firearm in a way in your own home that you think that it's secure, I don't know if it rises to that. It goes on to say circumstances and conditions in its use which, irrespective of a lawful purpose or due care, involve a risk of probable injury to such a degree that the activity fairly can be said to be intrinsically dangerous to the person or property of others. And I know people that own firearms. They're not keeping firearms in their home because they're intrinsically dangerous to others. They keep firearms in their home typically for their own self-protection. So I just see that strict liability is quite the stretch. And that refers to the civil liability. But this bill also makes that person who is in control of the premises criminally responsible and charges them with a Class D felony, which is a significant crime. Other Class D felonies include assault in the second degree with a firearm. That's different than failing to store your firearm in a way that's sufficient to prevent a series of events that no one could have predicted from happening. Strangulation or suffocation is a Class D felony. Sexual assault in the third and fourth degree are Class D felonies. There's plenty more. I won't go on to discuss them all, but these are serious, serious, serious crimes. And of course, this case is a tragedy, but what the person who would be in charge of the premises is responsible for is a long way from the actual tragedy itself. There's also an education piece in this bill, and I know that there are some folks who consider themselves to be pro-Second Amendment advocates who are very pleased that that education requirement is in there. I'm among them. I think that that is an addition to the bill that is welcomed. But honestly, the language in here doesn't guarantee that it will ever happen or that it will be implemented. And I think calling it education is also a bit of a stretch, since it's nothing more than a guide that would advise children, because that's who it's intended for, from kindergarten to age 12, that if they see a firearm that they should report it to an adult and stay away from it, which I think is good advice that anyone could and should give to their kids. I have an amendment, Mr. President. It is LCO 8754. I ask that it be called and I be allowed to summarize.
Mr. Clerk.
LCO number 8754, Senate Schedule A.
Senator Sampson.
Thank you, Mr. President. This amendment would strike the underlying bill and would provide a tax credit for a gun safe, the purchase of a gun safe. I move adoption, and I ask that when the vote is taken, it be taken by roll.
It will be so ordered. There will be a roll call taken at the appropriate time. Will you remark? Senator Sampson.
Yes, thank you, Mr. President. This amendment, as I said, is a very simple amendment. It doesn't get rid of the existing law, but what it does do is it creates a new mechanism, which I believe achieves the exact desire of what the bill before us is supposed to do. And that is to incentivize homeowners to store their firearms safely. I don't think the underlying bill achieved that. The underlying law, and I don't think changing a few words in that underlying law is going to achieve that either, especially since it's quite clear in the bill before us and the underlying law that it doesn't really go into effect until after a tragedy occurs. This is a real thing. People will go buy gun safes if we give them a tax credit to do so. What better way to incentivize people to actually store their firearms safely than to give them a reason that they can measure and see to do so? I urge my colleagues to support this amendment, Mr. President. I think it's a common sense solution to this problem. It doesn't undo the existing law that we are only making a tiny change on the edges of, and it creates a real incentive to create more safety in the situations we're concerned about. Thank you.
Thank you, Senator Sampson. Will you remark further on the amendment? Will you remark further on the amendment? Senator Winfield.
Thank you, Mr. President. First, let me apologize for when I was bringing the bill out. I went back to the other night. Now let me address the amendment before us. I rise in objection to this amendment. The amendment fundamentally changes what we are trying to do here. I recognize how we get to the amendment, but what we're trying to do here is the right approach. And let me talk about that approach, because I don't think this is just an emotional response. I think emotions generated the conversation, but there was a process in place where there was a hearing, there was a debate, about the bill, and after that hearing in a committee meeting, and now that bill has gone through the process and sits on the floor. And as much as I wish emotion worked on a lot of policy, emotion often does not carry the day because that's what the process is for. We get here because in the Judiciary Committee, 34 people thought we should be going here. We get here because this bill went through the House downstairs and came to this chamber. That's why we're here, not just because of emotion. I think we should rise and oppose this because the questions that Senator Sampson was asking as he led up to bringing it out are questions that can be answered. Reasonable person is a standard that we use in the law. All that it means is that we're talking about the average judgment of a person, the average skill of the person, and the average care of a person. We've used that standard before. It's nothing new. And it is an appropriate standard to use, particularly given what we're talking about. And yes, we're talking about strict liability, but it just means that it happened and the person who is the defendant in the case would be responsible, despite whether or not, as Senator Sampson suggested, they had done something. And I just want to talk about the issue, since it was part of the lead up to this amendment, about a babysitter, someone who's watching a house, and their responsibility. If you look at the bill itself that the amendment would be striking and replacing, all this says is that the person who's in control of the house shall not store or keep. Well, that babysitter is not storing anything, and that babysitter is not keeping anything. And if they were, then yes, they should be responsible. And so for those reasons, I rise in objection to this amendment.
Thank you, Senator Winfield. Will you remark further on the amendment? Will you remark further on the amendment?
I'd ask that when the roll is taken,
it's been requested already. Senator Sampson requested it at the time he brought out the amendment. Will you remark further, Senator Sampson? No? Will you remark further on the amendment? Will you remark further? If not, the clerk will proceed to a roll call on the amendment.
Immediate roll call vote has been ordered in the Senate. Immediate roll call vote has been ordered in the Senate on Senate Amendment A, LCO number 8754. Immediate roll call vote has been ordered in the Senate on Senate Amendment A, LCO number 8754, House Bill 7218. Immediate roll call vote in the Senate. Senate Amendment A, LCO number 8754.
Have all the members voted? Have all the members voted? If so, will you please check the machines and make sure that your vote is properly cast? Mr. Clerk, we'll close the vote.
Senate Amendment A, LCO number 8754. Total number voting 36. Total number voting yea 2. Total voting nay 34. Absent, not voting 0.
The amendment fails. Will you remark further on the bill? Senator Sampson.
Thank you, Mr. President. Well, I think it's unfortunate that the amendment failed, as I believe that that tax credit would have encouraged many, many people to go out and purchase a gun safe and ultimately store their firearms in a manner that would prevent tragedies in the future. And we can't really speculate on which approach would be more effective, but I'm glad we had the opportunity to consider it. I have another amendment, Mr. President. This one is LCO 8738. I ask that it be called and I be allowed to summarize.
Mr. Clerk.
LCO number 8738, Senate Schedule B.
Senator Sampson.
Thank you, Mr. President. This is a very straightforward amendment that would remove Section 2 of the bill in its entirety. I ask that I move adoption, and I ask that when the vote is taken, to be taken by roll.
Roll call will be ordered at the appropriate time. Will you remark? Senator Sampson.
Thank you, Mr. President. When I was going through the bill, I mentioned that I thought that some of the terms were very broad and that we could encompass a lot of circumstances that I don't think most of us would consider to be a situation where someone really is responsible for what happened, that they may have done their due diligence in a way to, at least in their own minds, protect against the potential of such a tragedy occurring. But that this bill does not take that into consideration and instead chooses to enforce strict liability in the event that something occurs. And for me, Mr. President, that is just simply going too far. We don't use strict liability in our laws because we like to give the opportunity for the court to look at the facts and determine whether or not there is a reason to believe that in this case, the person who is in control of the premises is truly responsible or not. That strict liability being in this bill takes it a step beyond where it should be in my mind, and I'd like to see it removed. A yes vote on this amendment does that. It does not change the bill. The law will still go into effect. The changes that are being made here will still go into effect. The criminal penalty will remain in effect. The only thing that's happening here is we are going to remove what I think is an unnecessary and overzealous element in the existing law, which is this strict liability piece. I urge everyone to vote in favor of this amendment, regardless how you're going to vote on the bill at the end. Thank you, Mr. President.
Thank you, Senator Sampson. Will you remark further on the amendment, on Senate Amendment Schedule B? Senator Winfield.
Yes, thank you, Mr. President. I rise in objection to the amendment. What this section of the bill does is it doesn't change what we have in current law, which is strict liability. What it does is it moves us from the age of 16 to 18. We've had a lot of discussion over a number of years in this chamber about, and in the legislative office building, about who are and who aren't minors, and we've made changes over the course of a number of years, and 18-year-olds certainly, the way we've constructed the law in Connecticut, are minors still, with judgment that is not the same as the people who sit in this chamber. So I would rise in objection and ask people to join me in voting in the negative. Thank you.
Thank you, Senator Winfield. Will you remark further on the amendment? Senator Whitkos.
Thank you, Mr. President. If I may, a question to the proponent of the amendment.
Please proceed, Senator Whitkos. Senator Sampson, if you would prepare yourself for the question.
Thank you, Mr. President. Through you, Mr. President, if this language is existing in our statutes regarding strict liability, has there been an incident that you are aware of or would share with us that have gone through the courts that folks have been impacted by that existing language? To you, Mr. President.
Senator Sampson.
Thank you, Mr. President. I appreciate the question. And honestly, I think I have that information here, but I have not reviewed it. It is in that OLR report I mentioned earlier, all of the cases that have resulted in a situation where strict liability was enforced. But forgive me, I don't have an answer to the question right now.
Senator Whitcoast, you have the floor.
Thank you, Mr. President. And through you, when you're saying is strictly enforced, would that be enforced by the prosecutor? Through you, Mr. President?
Senator Sampson, would you care to respond?
Yes, Mr. President. This strict liability applies to civil matters only and not criminal matters. So no prosecutor.
Thanks, Senator Sampson. Senator Whitcoast, you have the floor.
Thank you, Mr. President. And if the good senator could provide maybe an example, if you take a few minutes to go through your notes here, I'd like to get a better understanding of why we're changing or attempting to change existing law if it was brought forward in a civil suit, and what was the outcome, and what did they, if they held any standard in there, what were the implications of the standard? Through you, Mr. President.
Thank you, Senator Whitcoast. Senator Sampson.
Thank you, Mr. President. Just a quick look at the OLR report tells me that the existing cases in our current law have to do where someone is typically storing something that could pose a potential significant danger to others, more so than a firearm that might be owned by someone for self-defense. We're talking about the storage of ultra-hazardous chemicals, toxins. The most noteworthy place it shows up in our law is strict liability for the actions of a dog. In case of a dog bite, something like that, we hold the owner of the dog responsible. There are a few cases listed in this report. The first case they list has to do with the context of blasting and explosives. Whitman Hotel versus Elliott and Watrous Engineering in 1951. There's another case involving highly volatile chemicals in 1991. An illegal display of fireworks in 2000. There's a case of the storage of a significant amount of gasoline. Those are the kind of issues that show up in this OL report. Through you, Mr. President.
Senator Whitcoast.
Thank you, Mr. President. I thank this good senator for the answers to those questions. I had some concern when I initially read the bill on the strict liability. I was a little unclear as to how often it was utilized in our court systems, and I think I've gotten the answer to that. So I thank the good gentleman for his answers, and I thank you, Mr. President.
Thank you, Senator Whitcoast. Will you remark further on the amendment? Will you remark further on Senate Amendment Schedule B? Seeing none, Mr. Clerk, if we would proceed to a roll call vote on Senate Amendment B.
Immediate roll call vote has been ordered in the Senate. Immediate roll call vote has been ordered in the Senate. Senate Amendment B, LCO number 8738, House Bill 7218. Immediate roll call vote has been ordered in the Senate on Senate Amendment B, LCO 8738. Immediate roll call vote in the Senate.
Have all the members voted? Have all the members voted? Will you please check the machine to make sure that your vote is properly cast? Mr. Clerk, if you would call the vote on the amendment.
House Bill 7218, Senate Amendment B, LCO number 8738, total number voting 33, total voting yea 11, total voting nay 22, absent not voting 3.
The amendment fails. Will you remark further on the bill? Will you remark further on the bill? Senator Sampson.
Thank you again, Mr. President. I'll be very, very brief just to wrap up on the bill itself. Disappointed that that amendment failed also. I offered that amendment in all sincerity to fix what I think is a glaring problem in the underlying law and something that really ought to be addressed. That strict liability issue is a concern. Someone could make a diligent effort to store their firearm in a safe manner, and if they fail to do so through any kind of thing, the failure of the locking mechanism to work, circumstances beyond their control, they could end up being strictly liable. And I just think that is a shame that we would put that on the citizens of this state without the opportunity to argue in their own defense about those circumstances. And sadly, that's what strict liability does. The bill before us, as I said, only changes the existing law in a small, small way. It changes loaded to include unloaded firearms. It changes the word location to manner, and it changes the impact for minors under 18, or under 16 rather, to now under 18. And if I had the opportunity to have voted on the original law, I would have voted against that also. And the reason why is this is not an effective way to treat this situation. We are, by supporting this type of policy, reaching into the private residence of some other person and telling them what is appropriate for them as far as the safe storage of their firearm. There are people all across this state that own firearms, and they own them for their own personal protection. There are people that are in fear of their ex-husband, their ex-boyfriend, someone coming to hurt them. They live in a bad neighborhood. There's been a rash of crimes, and they feel comfortable having a firearm to defend and protect themselves. That is their right, guaranteed by our United States and state constitutions. And I don't think it's a good idea for us to be telling people how to handle that situation in their own home. And that's precisely what this bill does. And in effect, it does it very ineffectively because there is no punishment under this language unless a tragedy occurs. I think that's a result of the acknowledgement that we don't really have a right to tell people how to store their firearms. But what it does do is create a decent incentive in my mind to make sure that people do. And that's why the offering of the gun safe credit I thought was a better idea, because that certainly wouldn't violate anyone's constitutional freedoms, and it would give people the opportunity to store their firearm in a better way of their own volition that they might actually do just because of the credit. I also don't like the idea that someone who, through circumstances beyond their control or foresight, could end up becoming a Class D, I think it is, felon as a result of this language. I think that is simply creating another victim and is completely unnecessary. It doesn't solve the underlying problem, which we all want to address, which is to prevent tragedies like this. And as a result, I'll be voting no, Mr. President. Thank you.
Thank you, Senator Sampson. Will you remark further on the bill? Will you remark further on the bill? Senator Daughtry Abrams.
Thank you, Mr. President. I stand in strong support of this bill. As a former teacher and administrator, I can tell you that I was halfway through my career when the tectonic shift brought on by Columbine occurred. It's a definite before and after, and if you haven't experienced that, then I don't know how I could even begin to explain it to you. The part of this bill I would like to speak to is the part that talks about educating our young people. Every Town for Gun Safety in 2015 reported that at least 265 children under the age of 18 picked up a firearm and accidentally shot themselves or someone else. Accidentally. This usually occurs when kids find an unsecured gun at a home. They also report that although in the early years, the chances of those kind of accidents happening are high, they actually dip between the ages of about 8, 9, and 10, and then steadily begin to increase again through 17. 4.6 million of our kids live in homes with unlocked and loaded guns. We really need to do something to make sure that we protect our children, and I think this bill addresses that. It expands the age of education from grade 8 through grade 12, which is a response to the fact that we do see an increase through high school of these accidental shootings. It allows the State Board of Education, in consultant with the Connecticut State Police Chiefs Association, to develop guidelines and make those available to local and regional boards of ed. And in the one place I will agree with others in this circle is that although this bill does not require school systems to use this information, and being an educator, I would have liked to have seen that, I think that I can trust the advocates in each town to lobby their local boards of education to make sure that this gun safety is taught to our children. Lastly, I would like to thank the people in this room who allowed their love for their children to reach out and protect others from experiencing the same tragedy that they've experienced, and provoking the conversation and moving us to action. It will be my absolute privilege to vote for this bill. Thank you.
Thank you, Senator. Will you remark further on the bill? Will you remark further on the bill? Senator Cohen.
Thank you, Mr. President, and good afternoon. I stand in strong support of Ethan's Law. Many of you know that this legislation was born out of a tragedy that occurred in my hometown. On January 31st, 2018, a family was forever changed. A community was forever changed. It's the day that Ethan Song walked out of his house, walked down the street to a friend's house, opened up a closet, took out a box with an unsecured firearm, with the bullets inside the box, the keys inside the box, loaded the gun, and accidentally shot himself in front of his 15-year-old friend. Lives changed forever, and a life gone forever. I remember getting the news that evening and feeling such pain and sorrow as a parent and trying to relate to what the songs must be feeling. I remember talking to my own children about this terrible accident and what had happened and their attempt to make sense of it all. Their shock, their disbelief, and knowing that other families were having that same discussion with their children. I remember the days that followed, watching a family deep in grief and an entire community in mourning. What Kristen and Mike's song have gone through, no parent should have to endure. What they have done in the wake of this tragedy has been absolutely remarkable. With grace and courage, they speak to everyone who will listen about how to fix our broken laws. With grit and determination, they work closely with legislators to ensure the passage of this legislation. Because of them, in partnership with Representative Scanlon, who has done a tremendous amount of work on this, as well as Senator Winfield of the Judiciary Committee, and the rest of my delegation, we can create a safer situation for children and families in Connecticut, a safer Connecticut. Sadly, this narrative that I speak to today is not unusual. There are children dying each and every day due to unsecured firearms, needlessly. So I beg of all of you today, do the right thing and vote in favor of this excellent piece of legislation. Thank you.
Thank you, Senator Cohen. Will you remark further on the bill? Will you remark further on the bill? Senator Winfield.
Yes, thank you, Mr. President. I am rising to ask everyone to join me in voting in the affirmative. I want to say what I said earlier. Actually, let me make a remark to something that Senator Kissel said. The family is in a very unique club, a club none of us would like to be in. And unfortunately, I kind of understand that club. Not in the way that they do, but I understand that club. But that's not why we are standing here. Not just because of the emotion. That's what began this conversation. And I don't know if this is appropriate or not, but I give them a lot of credit. Because at the point that they're at, I couldn't have done what they did. But as I said, that started the conversation. But how the conversation took place is as all conversations in this building take place. There's an idea, there are advocates, there's emotion around every issue in this building. I don't know of too many issues on the committee that I chair that aren't emotional in one way or another to someone. But there was debate, there was concern for the law, there's conversation about the way in which we do this, and at the end of the day, the bill that is before us is a result of a process that brings us to a place where what we are about to vote on is a better law than what we currently have. And that's as it should be. And I would ask you, if you understand that the process allows for us to have conversation, to build better laws, and you understand that this was a conversation that has built a better law, that we've incorporated 18-year-olds who we now consider under the law minors, that we've asked people to lock your gun up in a safe container, whether it be a box or some other kind of container. And we haven't really changed the law that much, but in some ways, for some people, we've changed the laws in very significant ways after this vote. Then you would join me in voting in the affirmative. Thank you.
Thank you, Senator Winfield. Will you remark further? Remark further on the bill? If not, Mr. Clerk, please proceed to a roll call vote.
Immediate roll call vote has been ordered in the Senate. Immediate roll call vote has been ordered in the Senate on House Bill 7218. Immediate roll call vote has been ordered in the Senate on House Bill 7218. Immediate roll call vote in the Senate.
Thank you. Have all the members voted? Have all the members voted? Please check the machine to make sure your votes are properly cast. And I've been asked to remind the gallery that even on matters of strong interest and emotion such as this, our rules do not allow for demonstrations of noise in the gallery. So again, Mr. Clerk, if you would call for the the tally on this bill.
House Bill 7218, total number voting 36, total number voting yea 34, total voting nay 2, absent not voting 0.
The bill passes.